Thank you all. Attorney General Fitch, have I got your name right?
Yes, sir.
Okay. Do you feel like the people of Mississippi are to blame, or is China to blame?
Certainly China's to blame and must be held accountable, Mr. Chairman.
So, from your point of view, does this, the Foreign Sovereign Immunities Act need to be amended at all to allow you to move forward?
Absolutely. Now, we are moving forward because we believe that there is an exception that is already workable, and that's how we're proceeding on our lawsuit, which we filed in the United States Federal District Court of the Southern District of Mississippi. It's important to note that with the Foreign Sovereign Immunities Act, that the exception that is known as the commercial activity exception is an action based upon commercial activity carried on in China that causes a direct effect in the United States, and they may not be immune from the jurisdiction of U.S. courts. Defines commercial activity by reference to the nature of the course of conduct or particular transaction or act, and not by its purpose. And China was engaged in commercial activity, including the production, purchasing, import, and export of PPE, even essentially nationalizing the PPE manufacturing. So we believe this exception is workable, and that's why we're proceeding with our lawsuit. Now, certainly the amendment to the Foreign Sovereign Immunities Act would be extremely helpful, because providing additional exceptions provides us broader avenues for states and individuals to seek justice. There's no reason to restrict the tools in our toolbox.
Mr. Miller, what's your view of the argument she just made, your knowledge of the act? Do you think that the Mississippi lawsuit is justified under the current law?
My expertise isn't as strong in the area of the Foreign Sovereign Immunities Act as either the Madam Attorney General or my colleague, Professor Keitner. My survey of that legislation and the relevant rules led me to wonder if, in fact, there's an uphill battle for the plaintiffs in these cases, both under the commercial activities provisions or the territorial tort provisions. You're going to hear skepticism, I expect, about the functionality of those exceptions in this case from Professor Keitner, but all of that only then points to the necessity for amending the act if we want to move forward with these suits.
So the goal, from your point of view, would be to drive China in a consensual arbitration environment. Is that what you're suggesting?
Well, I don't share Professor Keitner's view that these domestic civil suits are more harmful, necessarily more harmful or futile. We have plenty of evidence that they can actually do what you've just described, Chairman, that they can move our foreign partners towards a consensual negotiation. But we also have evidence that they can turn towards providing actual compensation for American victims in a number of cases. The case against Saudi Arabia, justified under the exceptions opened up by the JASTA amendments, is moving painstakingly through the process, but holds out real promise for securing justice. I can think of one profound example in which civil litigation worked in tandem with the kind of international law processes I described, and that, of course, is the long and painful story of the Pan Am 103 terrorist attacks. And in that context, civil litigation worked profoundly to move Libya towards a settlement at the international law level.
Well, so my goal is to put as many levers on the table as possible to get China to change, compensate people in a fair fashion. This is the third pandemic coming out of China, and the consequence to our country and the world has just been astounding. So to go back to the old model where you just, I don't know, Ms. Keitner, do you support a pandemic tariff?
You're on.
Could you
Senator,
put?
Yes, I just promoted you to judge. Senator, I am not an economist. I do reference in the footnotes of my written testimony a report from the, I believe it's the American Economic Institute, that explains in convincing detail why that would be a terrible idea.
Okay, you don't support tariffs. Do you support sanctioning China?
Yes, I think in certain appropriate circumstances.
Can you tell me what you would do?
Well, obviously, the executive branch under the International Economic Powers Act has the ability to, and in fact has used that ability to impose sanctions both on a state level
What about
and on an
Congress?
individual basis.
What can we do?
You could give the president further guidance in the types of sanctions you would like to see him impose, as you've done with the Uyghur Human Rights Act recently. And I think those types of levers are the ones that are much less likely to boomerang back than the one that your colleagues are proposing here.
Can you give me an example of where sanctions against China has substantially changed their behavior?
Again, my expertise is not in China specifically, but I would point to the progress that we've made both with respect to economic espionage, although there does seem to be some backsliding there, as well as the trade deal that I was reassured to hear from our
Right.
president this morning is still in good shape.
I'll answer my own question, no. Absolutely no example of where doing anything under the current situation has changed China's behavior. That's why we're having the hearing. Senator Feinstein.